How is everybody today? I hope everybody had a wonderful 4th of July weekend. I had a wonderful weekend. I watched on Thursday night, I watched fireworks live from the Magic Kingdom. And then on 4th of July, we went to see Jurassic World Rebirth. It was excellent. Um, I have heard some people say it was as good as the first one. I don't know if I would go quite that far. It was very, very good. It was not what I was expecting. Um, I actually didn't expect it to be good because no one from any of the other movies was in it. Um, but I realized after I expected it to be horrible that nobody from the original movies was in Jurassic World and it was good. Um, but it's different. Um, but it was this I have to say I was on the edge of my seat more in this one. I think than I was in any of the other ones, even more than the original. Um, but I think like the tropes, like the bad guy tropes, and this is gonna happen and that is gonna happen, um, might have been a little more obvious just because of the other movies. But there were also tropes that they spun on its head, like you expected things to happen because of the previous movies that didn't happen. Um, it kept you on the edge of your seat. It was really, really, really good. So, don't be like if you're thinking about going to see it, but you don't know because it's, different people, don't. It's excellent and it's completely different than the other ones. You don't have to watch the other ones. You don't have to know anything about the other ones. It's completely different. Very, very good. Um, I can't wait for it to come out on DVD so I can add it to my Jurassic Park collection because it's that good. It's very, very good. Um, and then on 4th of July night, I watched fireworks live from Epcot. They did their normal fireworks show and then they did their an extra 4th of July fireworks. And then I stayed in bed and comforted Belle while Travis, my wonderful husband, went outside and did firecrackers all by himself for no reason while my dog was in the house scared to death. I told him not to, but he did it anyway. And they're not even like fireworks. They're just the ones that make the loud bang. And he came in when he was done and I was like, Belle was scared to death. Why did you do that? You were right outside the window. And he goes, no, I wasn't. I was way over there. And I was like, well, it sounded like you were right outside the window. She was scared to death and I told you not to do it. He goes, well, I'm sorry. I'm done now. Well, too late now. And then I kind of did like a movie marathon weekend because I hadn't watched movies in so long. And I'm in this like Disney mood for some reason. So I watched a bunch of Disney movies over the weekend. And then the girls came over yesterday because while we were at the movies, we saw the trailer for um the sequel to Wicked. And I was like, oh my God, there's another one? And they were like, yeah, it's the rest of it. And I was like, oh, I didn't know that it wasn't finished. I didn't know it was like in two parts. And they said, you haven't seen the first one yet? And I said, no. And they're, oh, well, we'll bring it over. So they came over yesterday and they brought the movie and they made a birthday, because Travis's birthday was the 2nd. They made a birthday cake for him. One of his favorite cartoons is Phineas and Ferb. So they made a Perry the Platypus cake for him. It is adorable. I took a picture. I forgot to upload it to the computer though. I was impressed. I was like, oh my God, that's Perry the Platypus. Well, it's gonna flip on me. See, isn't it adorable? It's Perry the Platypus from Phineas and Ferb. I was so impressed with that cake. I was like, that is too pretty to eat. I could not believe that my stepdaughter made that cake. That was adorable. So, that was my weekend. So, I hope that you guys had as wonderful a weekend as I did, because it was a very, very good weekend. So, let's see what Judy has for us. Oh, good morning, good morning. What musical is that from? Good morning to you. What is that from? Good morning, good morning. I don't remember. Great. Now I'm going to be singing that all day and not be able to remember what musical that's from. Spector Oddities. While a young Spector was enrolled in UCLA, he worked as a part-time court stenographer. Spector was a millionaire by the age of 21. Wow. It has been reported that Phil walked around his home every day. My God. It has been reported that Phil walked around his home every day in complete darkness, wearing nothing but a Batman costume. Oh my God. Oh Lord. Well, we knew he was weird, guys. Oh my word. Okay. We are still on. Oh man. Good Lord. What a weirdo. Is it being the millionaire at 21 that warped him, or was he just warped from the get-go? Okay, we're on the last bit of Dr. Bodden's testimony. Praise the Lord.
Correct? Thank you. Dr. Bodden, a couple of follow-up questions with reference to the jacket. Dozens and dozens of different positions of the jacket, both the right sleeve, the left sleeve, looked at. Were there hundreds of photographs taken of all these different positions?
Well, there were, I don't know, hundreds, but there were very many photographs taken of very many different positions, yes.
And was it your understanding that all these photographs were given to the prosecution by the defense?
Okay.
Dr. Bodden, with reference to the jacket and Lana Clarkson, were there positions she wearing the jacket? In other words, was her position how she was actually wearing the jacket when the gun was fired to see whether or not the buttons would be in a position where tissue could end up on them?
Yeah. The scientific evidence looked like at the time it was tissue from the mouth on, and to see how that would have happened.
Yeah.
And the jacket was, the left part of the jacket was put in different ways to try and see how it could have happened, given that we know there was tissue on the buttons.
Okay, looking at exhibit number W11, if we can have that put up. And is this the left sleeve of the jacket, kind of a more far-away view? And this is a picture taken by the Sheriff's Department laboratory?
This is another view of that same area of the jacket, yes.
Do we need the lighting down there?
He's retired.
Well, realistic.
He's not working anymore.
Okay, and when you looked at it, is this the same left sleeve area with the tissue that you talked about, the same buttons, or is it the right?
Yeah, yes, this is the same area, and no, and this photograph doesn't have the pink discoloration of the entire negative, of the entire photograph. And this, to me, doesn't look like blood.
Okay.
But I don't recall seeing blood in that area.
Okay, fair enough. And when you take a tissue sample, we could have the lights, please?
Wendy.
Thank you. When you take a tissue sample, can you sometimes in the tissue itself, if you take it and look at it microscopically, can you see blood that was in the tissue itself?
Yeah, one can see red blood cells in the tissue itself. All tissue contains red blood cells
Okay, and
on the
then-
inside.
If there's blood around the tissue, free-flowing blood, is that something different than blood within the tissue?
Yes.
What's the difference between the two?
Blood on the outside, freely on the outside, is not in blood vessels. Blood in tissue is in blood vessel capillaries in the tissue itself.
Okay.
So they're different spaces.
Okay, very good. I want to ask a couple of other questions regarding the jacket, and ask the jacket with this one here be put up, the exhibit N11. And I've got a hard copy for you to look at closer.
Thank you.
And this particular jacket was Mr. Spector's jacket, and there was no cuts in it. In other words, it was complete. Is that correct?
That was removed without cutting it, yes.
Okay, and was the mannequin used, a male mannequin instead of a female mannequin, used to position this jacket in the exact same way as the black jacket, only the difference being that Ms. Clarkson's jacket had already been cut because of the way it was collected?
Yes.
Okay, and were dozens, if not more, photographs taken of this in different positions used the same way that Ms. Clarkson's jacket was done?
Yes.
And what was the reason for that?
Just to document what was there, to document what was on the front, what was on the back, to document different positions, not positions that were determined to have occurred. When we were at that crime lab, we weren't determining what position Lana Clarkson's hands were or Mr. Spector's hands. We were getting all the different kinds of positionings so that when all of the evidence came in and all the crime lab information came in, and we were able to sit in our respective offices and think about it, that we could then try and figure out the positions of the two individuals and their hands.
Okay. Now, in addition to the jacket, you looked at the jacket to see if there's anything visible like soot or things that look like gunpowder, just grossly.
Absolutely, yes.
You had a little magnifying glass, you looked
I
at
had
it.
a magnifying glass, yes.
We had a stereo microscope, we looked at it.
Yes.
Stuff like that. Okay. And you read the reports of Dr. Harold looking at it?
Yes.
And you read reports of Dr. Harold doing some type of stickiness on the 4 inches of the sleeve of Mr.
the jacket.
Of the jacket, and then looking at it under a stereo microscope, something,
Yes,
and seeing one possible smokeless granule or something along those lines?
yes.
Mr. Jackson, I think, paraphrased what you said. You don't have any disagreement with that, do you?
No, I didn't do it, but I don't have any disagreement with it.
Okay, and basically, the entire jacket, the front panels and so forth, was looked at for, what might be seen to be soot from a gunshot.
Soot is part of the gunshot residue, yes.
And are smokeless powder granules also part of gunshot residue?
Yes,
Non-smokeless particles?
yes,
Burnt smokeless particles?
yes,
Okay. And unburned
yes,
particles?
yes,
And then we have primer residues, which are more specific, that is looked at under scanning electron
yeah,
microscope.
those are smaller, right.
Okay, so all of these different type of particles were looked at on the pants of Mr. Spector, is that correct?
Look for, I mean, the soot and particulate matter that can be seen with the naked eye or under a stereo microscope were looked at on the jacket, on the pants, on the shirt, other material that Mrs. Spector was wearing. They were looked at with a stereo microscope, yes.
Okay, so when, like, let's say the pants, they were looked at, they didn't see smokeless particles, non-smokeless particles, unburnt residue, what I call soot, that wasn't seen, and so they didn't look at it under the stereo electron microscope, correct?
Yes, that's a usual procedure. If you see a matter with the naked eye or under the microscope of a possible gunshot residue, then you do scanning electron microscope. If you don't see it, you don't do it because nothing's there.
Okay, and would the same be true of the shirt that Mr. Spector was wearing? It was also examined the same way,
Yes,
looking for the same things?
yes.
If Mr. Spector was looking at this exhibit N11, you could stand up for a minute. If he were holding a gun and pointed his finger right at you, would you expect that type of material to be fired a weapon inside tissue spattered upon him if he fires a weapon inside somebody's mouth?
Gunshot residues, tissue, blood, spatters, yes. On his sleeve, on his, the way he is holding it, the right side of his jacket, would find tooth particulate matter, the composite tooth particulate matter would have struck also.
In his hair?
They would have been in his hair, and it could have been in his face, in his pants, on his shoes.
Why would you do that? If you were the defense attorney, why would you? Never mind.
Did you consider all the physical evidence in this case, Dr. Baden?
Yes,
Did you consider all of the reports of Dr. Harold, the reports of Jamie Lintemuth, as well as others from the crime laboratory,
yes,
as well as all the materials that you were provided regarding the state of mind of Ms. Clarkson, the background information that you mentioned regarding Mr. Spector?
yeah, background information, including the bad things that he's done in the past, that reported, yes.
And together with your experience that you've had as a medical examiner, your formal education, and all the things that you've done in your career, as a forensic pathologist, did you take that into consideration before you came to an opinion in this case?
I did, yes.
Did anything that you took into consideration in this case bias you either in favor of Mr. Spector or against Mr. Spector?
No. My opinion was based on the scientific material and the autopsy findings, not whether I like or dislike Mr. Spector.
Okay. Do you have anything against the Los Angeles County Sheriff's Department?
No.
How about the District Attorney's Office of Los Angeles County that has employed you on numerous occasions?
I love the District Attorney's Office of Los Angeles County.
Okay. They've paid you money in the past, and does that cause you to be more favorable to them because they've been prompt in paying their bills to you?
I have great respect for the District Attorney's Office in Los Angeles and for the Medical Examiner's Office in Los Angeles County from my prior dealings with them.
Okay. Dr. Bodden, when you take into consideration your years of experience, your knowledge in doing the thousands of autopsies, going to the scenes that you went to, together with, is there anything in this case that tells you that Philip Spector is the person who fired the gun when it was in Lana Clarkson's mouth?
In my opinion, to a reasonable degree of medical certainty, there's no evidence that Mr. Spector's hands were on the trigger, on the gun, when it was discharged intraorally in her mouth.
I want to take the converse. Do you have based upon your years of experience, do you have an opinion that Lana Clarkson, for whatever reason, had the gun in her mouth and that was her thumb, finger, whatever, or was it her that pulled the trigger?
Again, in my experience, and I say reasonable degree of medical certainty because I'm not saying to all possibility. We can never testify to every possibility. 98%, 99%, to a reasonable degree of medical certainty, all the evidence that I reviewed shows that from the autopsy point of view, from the broken nail point of view, from the criminalistic point of view, indicate that Lana Clarkson's right thumb was on the trigger at the time it was discharged while the weapon was in her mouth.
Thank you. Nothing further.
Thank you. Recross. Thank you. You're not being excused at this time, doctor, but you may step down.
Thank you.
All right. Do you have another witness?
No.
All right.
We need to work out scheduling.
All right.
All right. Ladies and gentlemen, for today, we have finished with witnesses. Normally, we would resume on Monday. However, I understand one of the jurors now has a work commitment that they have to meet, and given that this case is now not running late actually yet, but it's getting to that point, I have no problem taking Monday off. We hope, and we missed by plenty, we might finish with witnesses next week. We're getting close again, but both parties have given me sort of an overview of where we're going. It depends on which witnesses actually end up testifying as to how long that's going to be. So I would say the testimony would finish, if not next week, the beginning of the week thereafter, and then we'll have some time for a jury instruction conference and then to get ready for argument. So that's where we're at. Keep in mind the admonition, and we will see you at 9:30 on Tuesday morning. Thank you.
Outside the presence of the jury. Yay. Quit buffering.
All right, back on the record, all parties present, visitors, and all. By the way, someone inquired of me about someone contacting juror number 14. He's been ordered not to discuss this case until a verdict is reached or otherwise instructed. And I would also, he is also caring for a very, very well-relevant, be inappropriate. He's under orders as well as any other juror who is excused until this case is finished. Be under similar order. Well, Mr. Renani, has something you want to say?
Just very briefly, Your Honor, we're going to have a motion in the morning concerning a subpoena just to take effect, and I just wanted to confirm that Mr. Spector doesn't have to be here for that.
There will be amendments.
Do I have to be?
You still want to bring the motions forward?
Oh, sure, no, I suggest they're not.
StreamYard, you were perfect on Thursday. Now you're going to get squirrely again. Kelly Dever, not Dever, has been placed on administrative leave of absence. No details available per BPD. Is it because of her testimony? She did what they told her to do. Kinda. Ooh. I kind of feel sorry for her a little bit. I didn't at the time because she was such a biscuit, but a young girl sees something and says something, and like she's almost threatened, you know? Like, you didn't see what you thought you saw. You need to do the right thing, you know? And she told them it was a false memory, which is what, like, they wanted her to say she didn't see it or whatever. So she said it was a false memory. But by saying it was a false memory, she did say that she said it at one time. I mean, she did her best. I don't know. I kind of feel sorry for her. She's young. She didn't know what to do. Poor kid. I mean, what would you do if that was in your... I mean, I guess, yeah, you gotta do what's right. But that's also your career, too. I mean, yeah, honesty is always the best policy, especially in this situation when a woman's life is on the line. But that's your career, too. Like, I mean, I'm not saying she should have lied, and she should have not acted like that on the stand. She should have done the right thing from the beginning. It's just, it's a hard situation. Like, you're between a rock and a hard place. Like, what do you do? I feel bad for her.
Yeah, Mr. Florida and Bruno, definitely handle it in my absence and do a terrific job, I'm sure.
There has been a letter generated to the defense that this matter for communications with the and this needs is just to show that before Ms. Kenneybottom came into the case, I guess that's where we're going. And the question is, the privilege that the defense calls Ms. Abrams, there's going to be at least a partial waiver on privilege. How much of a waiver is it partial or a complete waiver? I guess that's what everybody wants to resolve.
Your Honor,
Yes.
Sorry, guys. Before we go to the trial, I will clean my cash and cookies again and see. I don't know. It was perfect on Thursday. You think it was the attitude? Yeah, the attitude was not very becoming of a Boston police officer. Hey, Wiggles, we're talking about Officer Dever is on administrative leave. Probably because of her testimony at the trial, we're assuming. It crashed that time because I was trying to turn my camera off so that it wouldn't crash. And I crashed it trying to turn my camera off.
Judge, to focus your attention on the second portion that Mr. Dixon is referring to, take a look at the last paragraph beginning with the word additionally on page 3, going into the beginning paragraphs of page 4. That frames the second issue.
refreshing to read. Submitted, that's our position.
Okay.
After denied, we don't need it. I haven't actually seen it, but I can, that's never stopped me from arguing the point. If Ms. Abramson is called to testify about a specific communication or a specific communication at a specific point in time, that would be as far as it should be able to go. The idea that somehow the Menendez case information would, that somehow we would be able to control Ms. Abramson's production of evidence in a wholly separate case is, except for the fact that it seems to be written in sincerity, it seems to be a but in terms of the balance of the request for all communications, written, oral, or otherwise, I don't know, smoke signal, I guess is the other ones, but between Abramson and any attorney, investigator, expert, et cetera, concerning Biden, without a showing that it would have some relevance to what Dr. Biden's position was at the time that he first discussed it with Ms. Abramson, some months, if not years, prior to the time that Ms. Linda Kenny Biden got on, would be irrelevant and, in addition, invasive of the attorney-client work product privilege, the attorney-client privilege, and just not probative of any issue that would be before the court.
Well, I think I can answer. Thank you. Basically, that's why I said I didn't really need to read the motion, because these are similar to cases where you basically have to tailor privilege. You have to take a look at what's being testified to, and then you decide what the scope is that cross-examination can be allowed. So basically, in my mind, obviously, it can't go beyond her communications with Dr. Baden, but it's not so limited that it's one little tiny thing. The bottom line is, if you're alleging that Dr. Baden divulged certain information to Ms. Abramson, then the relationship between Dr. Baden and Ms. Abramson during her representation of Mr. Spector, all of that is fair game. It won't go beyond that. It can't go beyond Dr. Baden. It doesn't go to the other attorneys. It doesn't waive the privilege in its entirety. Obviously, Mr. Spector is not waiving his attorney-client privilege. But if you choose to call her, then her relationship with Dr. Baden, and anything within those parameters as it relates to this case, is appropriate.
When you're talking about relationship, what are you including?
That they worked on in this case, I'm not doing.
Communications to Dr. Biden and her concerning his testimony, is that the
His
relationship?
testimony, his investigation, his service as an expert.
Yeah, what was sent to him, that's sort of what we were
What they
looking
discussed, all those matters between Dr. Baden and Ms. Abramson in this case. Now,
We understand that.
I understand that you don't control, and frankly, I don't know what documents the people have asked, and this goes to whether Ms. Abramson could then be cross-examined. And my initial response is yes, and this has to do with what took place in the Menendez case, and I think you're talking about the Dr. Vickery.
Yes, correct.
Okay, well, without getting into specifics, I don't feel like going out of that in open court, but that is relevant to how Ms. Abramson views discovery and whatnot, and it also goes to her credibility and other matters. Now, I know you don't have control of the documents, and frankly, if they want to direct a subpoena to Ms. Abramson, they can, and I think it may be a little confusing.
Judge, with all due respect, you're mixing an apple with a plate of oranges here. There's no allegation that Leslie Abramson did anything improper vis-a-vis discovery. She's being simply asked what was her state of knowledge and what was the doctor's opinion at the point in time it's relevant. If she were being accused of withholding evidence or something, by some stretch of the imagination, what happened in that particular case might be relevant. But Ms. Abramson is not being accused of any improprieties vis-a-vis discovery.
Not, and I'm saying, I know what the people's position is going to be, and it's going to go, maybe there was, and maybe something was improper. The bottom line is her view is how she views discovery and her obligations, and also how she views her relationship with the prosecution. I think that's reasonable that her credibility be tested, and I have no problem with allowing her to be cross-examined on that. The witness can't shield herself. I'm not saying that she would like to or anything else. I'm not speaking for her. You're simply asking me what the scope of cross would be and what the scope of what I would allow to be testified. I'm saying that's fair game.
I think Ms. Abramson was here, she'd say, bring it on.
And you know what? That wouldn't surprise me, and that would be her position. She may say, let's go. No? Wouldn't be surprised at least.
If the court winds up finally going in that direction, I didn't hear it. I didn't hear it. That's my ruling.
Perhaps you didn't see the turn signal as I went around the corner.
It's possible. At any rate, hopefully you haven't quite made that turn yet, even though the signal may be in place. One of the things that I would want to discuss with the prosecution about this is maybe ferreting that out in a 402 hearing outside the presence of a jury.
Well, it's not just a matter of 402. I mean, let's assume for a moment. And again, we're just sort of going down a hypothetical situation, a hypothetical road. She says, I didn't do that, you know, as you know, because I'm familiar with that event. I believe that the State Bar never did punish her in any way. Dr. Vickery was suspended off of the court's list. I don't know whether the State Board, the appropriate State Board, took action against him or not. But it isn't a conviction. This is in the nature of legal testimony. And legal evidence.
Kind of a mini trial is what we're hoping we would
That's what we
avoid.
need to consider.
And by the same token, if we were to find any discovery missteps in the background of any of the prosecutors or officers that are participating in this case, that would be fair game as well.
Are they testifying?
Well, they're influencing testimony.
One thing we would have
Nice
to...
try, Mr. Brown. I don't think so.
You know, I see where the court is going under the Wheeler standard that is sort of different when there's no actual conviction or finding or whatever, but then we would ask that the people give us whatever information that they're suggesting. In other words, if they have some documentation. I'm not really familiar with Menendez and what happened there. I've kind of heard about it, but I don't have a
Well,
clue.
to give you an overview, and again, I'm not interested in trashing Ms. Abramson. We've been family for years, but the bottom line is what she was accused of doing was that getting Dr. Vickery to change a report that she considered to be unfavorable to Menendez. Okay?
That's fine. If we could just have that information. I think it would be helpful to at least me, I don't know about the other council, but we need, and hopefully Miss Linda Kenny Bond will be well next week. We'd like to look at that to see, because that might make a difference as to whether we want to have a mini trial on the issue.
And I realize that's why you're asking for me, you know, to sort of give some parameters, which I'm doing. Sure. You may want to speak to Ms. Abramson, and I get to see her reaction. Forgive me, I said just a moment. Can I be present? In any event, I'm sure those are things that you want to discuss, and you know, if you can't go forward with her on Tuesday, I don't know what to say. I guess it's just a matter of, you're going to have to make some decisions.
Sure, I understand. We understand.
One last thing, Mr. Rosen suggested in chambers.
All right, before we go there, there's it just occurred to me. We're going to deal with this motion to quash. You're here, Ms. Clarkson's here, I think your counsel's here. Is there any chance we could do this now?
Yeah, I do.
Sure. Up to them if they feel ready.
Yeah, sure. I'm John Taylor.
Step forward, let's do that now, and then we don't have to worry about it anymore.
I haven't filed a written motion or opposition to it.
Okay. Let's make some appearances for the record, please.
I'm John Taylor.
Roderick Lindblom, representing the party.
Okay, there's a motion to, I think a subpoena was issued on the final.
It's attached to the motion that was filed, motion to quash. Somewhere in all my materials, I actually have the original motion, the original subpoena.
Right now. It seeks, and you put a writer with R-Y-D-E-R.
That's the way I've done it for years. I learned from some civil lawyer that was the way to do it. I don't know if it's correct or not, but that's the way it is.
All right, but in any event, provide it's directed to Ms. Clarkson as follows. Any and all writings, documents, computer records, day planners, notes, letters, emails, loan requests, debt records, business records, calendars, or contracts written by or received by or relating to Lana Clarkson. Any and all writings, documents, computer records, day planners, notes, letters, same subject matter to Living Doll Productions. Any and all financial records, including bank records for and relating to Lana Clarkson. Any and all writing documents, computer records, day planners, calendars, notes, letters, emails concerning Lana Clarkson's state of mind or mental state. Any or all writings, documents, medical records, and or psychiatric and or psychological records relating to or concerning Lana Clarkson. And then there's a definition of terms, which I don't have to worry about now. So that's the categories and the items you see. Okay, I'll hear from you. It's your motion.
We filed opposition with the court, and basically it's so overbroad that we don't know specifically what it is that they're looking for. I had a conversation with Mr. Brunon 2 days ago, I believe, and he tried to narrow it a little bit, and I can respond to those particular items, but beyond that, I don't know what privileges could possibly be even raised, given the breadth of the request, not only in the scope, but it's unlimited as to time, et cetera.
Well, I can take care of the psychological and psychiatric orders. How do you pierce the privilege, assuming Ms. Clarkson is the appropriate person to claim it through the counsel?
We believe that the privilege doesn't imply that there's been no foundation or no demonstration that Donna Clarkson is in a position to claim the privilege, or anybody else.
Well, they can establish that, and then we'll see. It certainly can survive death, I know that.
Yeah, there has to be a probate open at time. If there's no probate or the probate's been closed, then the privilege evaporates as we read the law. And if Ms. Clarkson, I don't know whether she is or not, if she is the probate...
Excuse me, if there is some law if probate is over, what about if it has to be probate? Do you have a case for that?
Well, there's a case that I've read that talks about it doesn't survive the probate closing, and there are a lot of cases, and I've had cases where there's been no probate because there's nothing to probate, then there's nothing, the privilege never actually survives at all.
There's a section.
Yeah, 1016, and actually we had a brief somewhere on that, but I don't know if I have it with me, but what we don't know whether there's even a probate, whether she's been capacity to be representative of the estate or not, one way or the other. At least that's not been demonstrated. The only thing that's said in the motion is that they've made these materials available to us. That's not necessarily correct. I mean, she's represented by counsel. We've not contacted her to go look at her records. I don't know, maybe the people have, but we haven't.
Your Honor, there 1013 refers to holders of privilege, and it does include of the patient if the patient is dead. The use notes refer you back to 993, which refers to the medical privilege, and the use note there says there must be an estate in existence for there to be a personal representative. If there is no, and that would be the only potential holder of the privilege in this case. The patient's obviously not a holder at this point. There's no guardian or conservator of the patient, so it would have to be the personal representative, but that, as the court says, requires an estate for which there to be a representative. In addition, the fact that there's a lawsuit pending by Donna Clarkson in her individual capacity as well as others would, under 1016, eliminate the privilege because the cause of action goes to, in part, the state of mind of Ms. Lana Clarkson.
She didn't put her state of mind in it.
No, I'm not attorney.
No, but in the civil suit where Mr. Spector is a defendant, she's already filed that. It's basically pending, and she put it in issue. So the privilege is waived. There's a case that says when the civil suit is filed, it's waived. So if it applies, it's been waived is our position. But we don't even think it's applied.
And the state of mind is an issue in this regard, not directly, but indirectly, because the same issues are present there. Who was the person that shot the gun? Our position in the civil suit, or the defense's position in the civil suit, is the same as it is in this case, and that is that Ms. Clarkson is the person that held the gun and discharged the gun. Her state of mind vis-a-vis her depression and other emotional circumstances are relevant to that cause of action. And there is a case, I have it here in this stack, I didn't know we'd get to it, I'll give you the
Sorry about Patterson.
I'm talking about that. I said yes, sir, and I gave it to you the other day. And that, I think, a parity of reasoning, the logical deconstruction of the issues in that case apply almost directly here.
In addition, assuming we get through hurdle 1 and hurdle 2, 1 is the privilege applies, 2 it's not been waived, we believe that there is a lot of federal due process, federal constitutional authority for the proposition that it's not an absolute privilege. The court should look at the materials and then weigh the competing interests, the right of Mr. Spector to get a fair trial, due process of law, to see whether or not these materials should be turned over in any event. It's a privilege. And this applies just to the the last part of the, for the psychiatric, psychological records and so forth. So we would ask the court to consider not only issues 1 and 2, but if we ever get there, issue number 3. If for some reason the court sustains the existence of the privilege, the lack of a waiver, and whether it gets to what we call the third prong of, are there materials, we would ask that the court review those, give them to us if the court makes judgment that they're not. If not, then look for the record and anybody look at it so that we at least made a record of that process so that we know later on, in the unlikely event that this court's decision would ever be reviewed, then we would have that in the record, not for us to look at, but for the reviewing court.
First, as to whether there's a valid holder of the privilege.
There was no estate that was ever owned. And Mrs. Clarkson's the wrongful death case that was filed on February 3rd, 2005. At that time, there was also a successor and interest document filed, which allowed the lawsuit to be brought in her individual capacity and as the successor and interest. That is the proper holder of the privilege, and everything they've said doesn't take it out of that. I mean, she is the successor in interest in the wrongful death case. She's the holder of the privilege. We're asserting the privilege.
That's not legally. I don't think that's the same. The wrongful death statute basically allows a representative of the decedent to sue in the name of the heirs, and in that representative capacity can facilitate the lawsuit, which she could be also. But as far as Ms. Clarkson's personal property, this is what we're talking about. Her papers, for example, the letters that we just received, which came through the district attorney's office, all the papers, the couch or whatever, the computer, that material is not part of that lawsuit. That's just material that she had once had that Ms. Clarkson, we believe, has at some level custody and control over. That's the type of material we want. That civil lawsuit is not going to adjudicate whether or not the emails on the computer should go to one person or another. There's no probate open. So there's no privilege at all here. We checked. We didn't think there was a probate, but we weren't sure. We didn't want to say there wasn't until they said that. But there's no probate. There's not going to be any probate. There's no privilege to the extent that they make the argument that there was this wrongful death claim being made. That clearly waives the privilege. It's been waived for the wrongful death, etc. And we feel that we're entitled to the documents called for, including the psychological, psychiatric records, which I would assume are very relevant. Now, maybe there's record in there that the court would review that would not be relevant to this case. I can see that's possible, but based upon what we know, we think that there's a lot of records in there that might be very pertinent. We'd have to ask the court to look at those to try to assure that our client gets a fair trial.
Mr. Brunon is whispering soda voice in your ear. What?
We hadn't departed the psychiatric privilege, have we? Or had we?
We haven't departed it.
Okay. Because I think there's different considerations for the record in the last category as for the balance of the item.
Well, I'm going to get to that. I'm going to indicate, I'm going to need the moving party to file some points of authority with me, and you have until Tuesday morning. You already know what the issue is. If you want to file some points of authority, you already know what they're going.
Right.
To show that this is a valid claim of privilege.
That's fine.
Okay. Now, moving past that, assuming that Ms. Clarkson is the appropriate person and the privilege exists, what are you having a problem? You say it's too broad. You say you limited it somewhat, Mr. Brunon?
When I spoke to Mr. Taylor, I didn't have the document in front of me, but I said what we were really critically concerned about was her desktop computer, which wasn't taken, her 2003 day book, and any other correspondence and communications that were found within the residence that are basically readily available. And I suppose we could narrow it time-wise to the year 2000 or 1999 forward, so we don't need things. In terms of the categories, emails, correspondence, other forms of documentation that particularly pertain to her employment, her state of mind, her general emotional condition, the items that we have found to have relevant information up to this point. If there's other things out there, we would like to have access to them.
Yeah, one thing that we learned when we got this slew, literally many thousands of pages of emails off the computer because there was a glitch. I don't know how it happened, but we both sides just realized there was all these emails. They referred to bank problems, overdrafts, things like that. So, for example, the 2001, 2002, the relevant time periods, the checkbook or bank records that go for that period of time. I mean, that type of thing, along with what Mr. Bruno was saying. But we are willing to focus in on things and, leave it at that. Debt records, she talks in one email like I've got a stack of bills, unpaid this, I owe $3,000. These are all referred to secondarily in these emails, and there's something behind that, we think, and we'd like to know the substance and accuracy of that.
When I spoke to Mr. Brunon, he was concerned primarily about two things. One was the day book of 2003. There is no day book. Lana Clarkson did not have a day book for the calendar year 2003.
Anything that comes close to being a day book?
No. And then the second item that Mr. Brunon was concerned about was the desktop computer. And I think there was testimony during the trial that when the cottage was examined by the Sheriff's Department, the laptop computer was taken into custody and a mirror image of the hard drive has been made available to the defense. The desktop computer, there was nothing that was generated from that computer. To my understanding, it was broken and was turned over to Goodwill or given to Goodwill at or near the time of her death.
They don't have the records, it's a moot point, they're not going to borrow that.
All right, that's fine. So now what about these other items? Why can't you produce them? I'm not saying that they're discoverable. I'm saying you indicated that they're overbroad, but you don't know what to look for. Other records other than computer records.
Well, I mean,
records, bank records. I'm going to limit this from the year 2000 on. That's going to be a starting point. That's relevant.
Well, the first time that we heard about this, Ms. Clarkson was served, I believe, sometime on Monday morning. And I actually didn't get a copy of the subpoena in my hands until sometime on Tuesday afternoon, and then I spoke with Mr. Brunon on Tuesday evening. If the court's, we still want to talk about privilege as to the one record.
Here's what I would suggest. I think it is, the items are identifiable from 2000 on. I would suggest that you spend the next few days gathering them. Put them in wherever box or boxes as the case may be. Go ahead and brief the privilege issue. I'll rule on the privilege issue as soon as I can get to it next week, and then at least I would have documents to see that they're relevant. At least I would do it in camera, and then if I found something that I thought was relevant, I would turn it over.
Is the psychological, psychiatric records, should they be kept separate, like in a separate?
They should be sealed separately, and I won't even make a decision as to whether I would even go into those, but we'll get to that.
That's fine.
Okay?
Yes.
All right, so the motion for tomorrow is off calendar, and I would suggest you remain in communication with each other.
Yes.
Okay?
Thank you, Your Honor.
All right, thank you. Do you want to go in camera?
Yes.
Okay, let's go. So this is in camera. This is with or without the people?
No, with the people.
All right.
May Mr. Spector be excused?
Yes, he's excused.
Okay, let's see. Next. More outside the presence of the jury. Why more outside the presence of the jury? StreamYard, knock it off.
Council, including 2 lost lambs who have returned to the flock. And the people are present, the jurors and the alternates are not present. Ms. Kenny Bodden, I hope you're feeling better.
Thank you for your courtesy.
Okay. And nice to see you. We have, so I am now prepared to rule on the issue of privilege. I've had a chance to find the case that I needed. So how would you like to proceed? Okay, well, on the issue of privilege, counsel are present. They have filed a brief basically asking me not to equate, believing that the law does not equate the meaning of holder of the privilege or with the probate code, and actually there's a case that says I should. And that case is Bowling versus Superior Court, 105 Calap 3rd 430. And therefore, the court is holding that there is no privilege that exists in this matter. There's no holder of a privilege to exert it, and therefore it does not apply in this matter.
Thank you, Your Honor.
All right?
That means we shouldn't argue, I think.
Would you, if you want to, snatch victory from the jaws of defeat, yes, or defeat from the jaws of victory.
Gilded lilies,
I see nothing has changed. It's nothing gone.
Not a thing. Not a thing. Just time passes on. All right. Okay, what else would you like? Thank you.
Okay, you're welcome.
I appreciate it.
John Taylor.
Yes, thank you, Mr. Taylor. And I have, you have turned over to the court pursuant to the subpoena a list of items, and here you are.
Well, my understanding was,
You want me to review these for something?
I put a letter in there for you to review first before.
I'll take a look at it, though, since there's no privilege. I mean, there may be something that shouldn't be turned over. It's possible that...
Yeah, there was going to be 2 envelopes, one with the psychiatric records.
Okay.
Another one with all the other records. So
All right, I'll take a look at them.
They're very good. Thank you.
Okay, thank you. All right, thank you very much. You're welcome. Okay, let's see.
As to the witnesses, the 2 psychologist witnesses, the ruling is the same.
Yes.
We will either get them here or work out a stipulation.
Okay, that's fine. Thank you. What else? Is there anything else we should take up? Mr. Jackson, anything you want to take up?
Your Honor, the only, what did we talk about? With regard to, if the defense is seeking the admission of medical records from Dr. Batra and medical records from Dr. Kudrow, we have an objection to those based on not privilege, but our initial thoughts were they were privileged. Even if they're not privileged, we've looked through the medical records and we have an objection based on the foundation of those, not the foundation, the relevancy of those, given the fact that they are completely out of context. They're medical records and you can't make heads or tails out of them. They're written in, they might as well be written in Greek. I don't know what portion of the medical records Mr. Plourde is seeking to have introduced from Dr. Batra, from Dr. Kudrow, and I haven't heard an offer of proof as to exactly why they want the medical records in. And until we hear that offer of proof and are pointed to specific pages, I can't really address it. But to just flip through the medical records in and of themselves, they're handwritten notes from 2 different doctors, that both of whom saw Lana Clarkson for her headaches, not for any psychological reasons, and they don't make any sense. I mean, I can't read them any more than you can. The judge is going to be able to read them. So I'm a little confused as to why and what the defense is seeking with regard to those medical records.
Mr. Plourde?
Both of them have been previously marked as exhibits, and
That may be, but what is the relevance? What are you attempting to show?
Dr. Batra, if I'm pronouncing it right, it has the patient history with a lot of background and shows the severity of her medical conditions. It describes her headaches. It talks about her problems with bleeding. It's the multiple check marks that she puts where she puts a medical history and attaches that to it. She gets into some other things, and there's some things that we're going to basically black out or delete that the court has previously ruled on. But basically, it's her medical history as of the time that she sees Dr. Batra in early 2001, right before her accident injury, somewhere in that time period. And then she sees Dr. Kudrow between that time and the next time. And plus, he ties into the records for Long's Drugstore, which were also moving into evidence, as being one of the persons that was prescribing certain medications for her. So the records sort of tie into all the exhibits. Dr. Kudrow, we're moving to have his records admitted because he treated her for some type of headache disorder. The court has said on the record that he gave Ms. Clarkson Paxil and Elavil for headaches, but the records don't bear that out. And so the records sort of impeach that. Now, I don't know why the court
said that
in front of the jury. And Mr. Jackson has contended that. I've had a lot of discussions with Mr. Ocampo, and he says that that's what they had heard from Dr. Kudrow. That's not in the medical records themselves, unless I'm misreading the records. I don't. I looked at him again, and it doesn't say that in the records. It does show that he prescribed that, but it doesn't show why he prescribes that one way or the other. So I believe the records impeach that position that has been taken, and the court's basically said that. Now, I think
I'll correct it if you can show me. I'll obviously happy to do it.
But it may be that they called him up and he said that verbally, but that's not the proof before the court. So I don't know whether that's something that's true, that's just not in the records or whatever, but we don't have any proof of that. And given her Cedars-Sinai records where she says she was treated for depression, I've got a question in my mind, at least, as to what she was treated for, by who, whether it was Dr. Kudrow or somebody else. I mean, there's evidence that she's seeing doctors out of the country. I have no clue what that's about other than her email.
Well, wait a second. Why can't you talk to Dr. Kudrow if there's no privilege?
We've called him, and he says he's not talking to us because there's a privilege. He's maintained that along.
Then subpoena him.
Okay, well...
I mean, I'm not suggesting you do an act or not do an act, but the obvious solution to this, to find out if he will not talk to you, is subpoena him, because I've ruled that there's no privilege, so I don't find it improper.
Paxil and Elavil are both antidepressants, but they're also used for certain types of pain. I'm on Elavil for fibromyalgia because it works good on chronic pain conditions. So I can see her being put on Elavil for migraines. It never helped my migraines. It made them not quite as severe. I could tolerate light better and sound better, but it didn't stop them. So it is possible that the Elavil could have been given for the migraines. Don't know about the Paxil, though.
That he claimed that psychiatrists often think that the privilege, they have the right to claim it, which they do under certain circumstances, but not in this case.
Yeah,
He's not a psychiatrist.
He's not what is he?
He's a neurologist.
A neurologist.
For headaches.
Okay, well, in that case, there is no privilege because, first of all, the medical privilege doesn't apply to criminal cases, plus which the patient's deceased.
I understand that. He's claiming a medical...
Privilege survives death. And HIPAA was in place in 2007. So there should still be privilege. How does privilege not apply?
Privilege, he's just not talking. Maybe he's just one of those doctors who don't want to talk to lawyers. I mean, there's a lot of doctors like that, believe it or not. But in any event, the records themselves don't purport to show what Mr. Jackson is saying.
If you cannot resolve it,
okay,
and then I will be happy to say that there's nothing in the record. If you can come to an agreement that if I said that, I'll be happy to say at some point I said it's on the record. The record does not support it.
Okay, and then we moved the Long's Drugstore records in also. They're already marked as an exhibit. There's this.
Having said all this, you never did directly answer my question. You said you want to show her medical history, but it still has to be relevant. I want to know what portions you want to put in so that I can take a look and say, are these relevant to this proceeding or not?
Yeah, as to Dr. Bonter, it's her description of her history, both personal history.
What does it say? That's what I want to know.
Severe headaches, severe pain, bleeding disorder. Those are the three principal ones that we want. And
why is bleeding disorder in quotes relevant?
Well, because she's on a medication that makes one more susceptible to bleeding.
Okay.
Okay. And
all right.
And bruising, bleeding, whatever.
I understand.
And so she actually affirms that in her medical history records when it says, what problems do you have? Check, check, check when it comes to bleeding problems. And she does the same thing with headaches, severe, multiple checks. It just shows the severity of the issue. And so this history is 3 or 4 pages, and some of it is relevant, some of it the court has ruled is not relevant. So although I think Mr. Brunon's going to argue that one aspect may have been opened up and we now think is relevant, but we'll argue that at another time. So in any event, I'll get the exhibit number. I'll tell you which pages we want. Maybe we can work out a stipulation. And
I would suggest you do that, and if you have a specific objection that something is not relevant to these proceedings, tell me what the specific entry is.
Right.
That's fine.
If the court recalls, we had the record up with Dr. Pena. There was one portion that the people decided to object to. The court told me to take it down. But Dr. Pena testified that these things were in the record. And
I have thought about that since, and that may necessitate a change because it was testified to, I believe.
Right, and that's why I'm thinking the records kind of go in to understand Dr. Pena's testimony. The other experts pretty much said the same thing, although they didn't deal with the records per se. Then we've talked at length about the Long's records with Dr. Pena. Those should come in. So that's our...
Okay, well, my point then would be if you have a specific objection to a specific portion of the records as not being relevant, then pick it out and let me know. It sounds like some may be relevant and some may not be relevant.
The one thing, and excuse me, Mr. Dixon, the one thing that I want to make sure that we're clear about is if I hear Mr. Plord correctly, he's saying that since there's no reference that he can find, a specific reference in a lot of the chicken scratch in Dr. Kudrow's records specifically that he can find that indicates that the Paxil was medicating headaches, not depression, that he wants to be able to introduce the records and mislead the jury by saying, see folks, I see Paxil right there, and Paxil is known to medicate for one of the labeled uses is for depression. Therefore, you should assume that this was for depression. That is 100% misleading, and Mr. Plord knows it. Dr. Kudrow is a neurologist. The sign on his door says Southern California Clinic for Headaches. And because the word Paxil or Elavil show up in these medical records with chicken scratch that you can't make heads or tails out of, he wants to get up in front of this jury and say, see folks, Elavil and Paxil, depression, that's what she was being treated for. That is misleading. I can't believe that the defense would seek to present these medical records for such a misleading use. That's absolutely inappropriate.
I'm listening.
My mouth is agape. I'm dumbfounded if that's what they're saying. Well, Mr. Jackson can't point to any place in the record where it says for headache use, except for the fact that Kudrow was treating her for headaches. And he indicated he's treating her for headaches.
Does that appear in the record?
It's on his letterhead. California Headache Clinic.
It's unclear from the records what it was for, one way or the other.
If he was treating her for depression, Judge, he would lose his medical license. He's not a psychologist or a psychiatrist. He's an MD neurologist. He treats brain problems and headaches, not depression and psychology.
I don't want to take a doctor away from his practice, but somebody really needs to subpoena this person so we can just tie it down as a matter of fact.
That's fine. If the defense wants to do that, that's fine.
Well, I talked with Mr. Ocampos here, and I said, look, where do you guys get this idea that it's for depression? Because that may be true. I don't know. Or be for headaches. He said that somebody called him and got an interview with him. I said, well, where's the report? Well, we don't have a report. So that's where we're at. We're sort of in a position where supposedly Dr. Kudrow says that he won't talk to us. We've tried multiple times. I said, if you show me a report, if there's some statement that he made, then so be it. Then I'm not going to fight City Hall. But the thing that makes this more of an issue is, and again, it may be Dr. Kudrow, it may be some other doctor, but in the Cedars-Sinai records, she tells her treating doctor that, what have you been treated for? Headaches and depression, or some depression, I think is her actual language. In other words, that's her past medical history that's in evidence there. I don't know whether that's Dr. Kudrow or somebody else, and I'd really like to know that. I mean, I think that would be important for the issues in this case. But it is what it is. He does give these medications. Maybe he did do it for depression. Maybe he didn't. Whatever the facts are, so be it.
Mr. Dixon.
Thank you. Just to follow up on it, our original objection somehow got lost here, but it's part of what's going on here. We can't understand what's in these medical records. There's scribbles and scratches, and it looks like hieroglyphics. And I don't think they can anymore, but any more than we can. The point of it is they want to introduce this stuff to the jury and then basically testify during argument as to what they mean. We think that's inappropriate. The way that's usually done in something like this is with a stack of records that nobody can understand, is to have an expert, and there's lots of these floating around, especially in the civil courts, get up and tell the jurors what's in these medical records. But they're going to submit these, nobody can read them, and then they're going to basically testify through argument as to what they think it means. I just don't think there's any foundation for these records. They're unintelligible for the most part. When he says Paxil's in here for this or that, he's testifying because most people can't tell by looking at this, and many of the jurors may not be able to.
Okay. Well, there was an objection that came that it was, the Paxil was given for headaches, and the court said that's right. In front of the jury, that's what we're trying to rebut, is that affirmative position, which I don't, at best, it doesn't show one way or the other. So
Let me say this. First of all, I believe that more than one witness, or at least one witness, has testified that she was taking Paxil. Am I correct in that?
no question about that.
Okay. To the extent that the records show that she was taking Paxil, I believe we're talking about Dr. Kudrow's records, that can be introduced to corroborate that indeed she was taking Paxil. You also have a fact, or you can introduce a fact, that Dr. Kudrow, or put in his letterhead, that he treats headaches. They're going to try to argue that he was treating depression. Where are the facts for that?
Correct.
That can be, you know, the bottom line is you can deal with that in your argument or whatever. There's nothing to support it.
The only other thing...
But the records, to the extent that they reflect that she takes Paxil, those would be admissible. They corroborate what other people have stated that she was taking Paxil. This is an indication that indeed she was.
And if the court harkens back to Dr. DeMaio's testimony on cross-examination, I asked him about his review of the medical records, and he admitted, you know what, Mr. Jackson, I was incorrect about my assumption as to why she was taking Paxil. In my report, I wrote that she was taking it for depression. That was wrong. He said that on the stand in front of the jurors.
Okay. So but the bottom line is that the records, to the extent certainly that they reflect Paxil, would be admissible. As to whether they argue that we don't know why she was being treated for that, it's possible, but you can certainly point out if you have facts or present them or put it into evidence, and I'm not suggesting you do or you don't, as to what Dr. Kudrow's specialty is.
Sure.
Okay? Sure. And there we go from there. What else?
That's it. And I would want to put on the record that we're not going to be calling Leslie Abramson based upon the court's ruling regarding the prior incident with the Menendez case.
That she could be impeached.
Right. We made a decision after the court made that ruling not to do that as of yesterday morning.
All right. So who is the next witness going to be? Mr. Rosen?
Well, I had something before we get to that.
Go ahead. All right.
I spoke with Mr. Jackson and Mr. Dixon a moment ago. Since they indicated they were not going to have any foundation objections to the emails, I suggested that I hand this up to you so you can start taking a look at them, because then it comes down to the question of relevancy, materiality, and of course whether or not each and
Slow down.
each and all...
Not that slow.
Not that slow. Each and all of them qualify under a state of mind exception. So I've got the packet. They have no objection to it. It might save us some time and jury time. So I'd like to hand them to the court so you can start taking a look.
Okay. Now, the next question. So what are we going to do now? Can I have some help here, folks? I don't call witnesses.
Well, as we indicated in chambers, as soon as the defense rests, we have a witness.
That's right. And so what is the defense doing now?
I think we're at the point where...
Because there's some things I have to do if you're...
Subject to the psychologist being contacted, we're going to rest provisionally.
Exactly.
And moving exhibits in and records. And
Okay, with records, we can probably take care of at some later time.
The records and exhibits we can do on...
So you have no other witnesses at this point?
That's correct conditionally, so we will rest at this time.
Okay, before we do that, then there's something we need to take up now. Mr. Spector, I need to address you. I take it you're not calling Mr. Spector?
We are not sure.
Okay. Mr. Spector, you need to have me explain to you, and you need to understand as soon as Ms. Kinney-Bodden is done talking to you. Although I understand, the defense, as a matter of strategy, for whatever reason, has chosen or indicated to me they are not calling you as a witness. That right is solely yours. In other words, even if your counsel told you, we don't want you to testify, if it was your decision that you wanted to testify, that would control. So basically, understanding that, do you wish to waive and give up your right to testify in this matter?
We're just a little bit higher, but I want to make sure the recorder can hear.
Yeah.
All right, thank you. Council joins?
We join you.
All right, thank you. Other follow-up matter. Last week, it had been reported to me, and an individual was named, that they were talking loud enough, that they were expressing opinions. Some of the jurors had indicated they had heard this person, and the person was identified to me as the young lady in the white blouse. Is that correct? She's not the person. So you are not the person I should have been addressing my remarks to. I apologize. You were misidentified to me. You're not the person that was doing it. It was somebody else who has tentatively been ID'd to me, and rather than single that person out, I will simply reiterate at this point, who's ever in the audience, keep your opinions to yourself, because if you don't, you're gone. It's that simple. Your opinions, you're free to have them, but I don't want the jurors hearing them. It's that simple. Okay. So, are you ready? Then we'll let you rest subject to review of records and introduction of exhibits. That will be done in front of the jury, and then you're prepared to proceed.
Yes.
Are we ready for the jurors?
And of course, the issue is psychiatrist.
I'll read this as, if we have minimal objections, I can do it on the bench. If not, I'll have to do it over the noon hour.
Well, I'll just say this. We did try and choose ones that we felt
I understand.
were most appropriate within the confines of materiality, relevancy, foundation, and state of mind.
Okay, are we then ready for the jurors?
Yes.
All right, let's bring them out.
Man, Rosen is such a brown noser. Good Lord. I swear, I cannot stand that man. Robot, I have no idea. Music composer. I thought we were almost done. They're talking about closing and jury instructions. Why are we still got witnesses? I'm ready to be done with this one, y'all. I don't know about you. I guess I need to start thinking about the poll for the next Trials of the Past. StreamYard, you can do it.
But in your absence, we have been resolving certain issues which should help us finish the case, hopefully this week as far as testimony is concerned. That's now what it looks like, subject to last-minute changes as always, but I believe that we will finish testimony this week. Does the defense at this time, subject to introduction of exhibits and subject to the possible, once the court reviews some records, possibly calling one or two other witnesses, you rest at this time?
Yes, we rest.
All right, thank you. Do the people have any evidence in rebuttal?
We do, Your Honor.
All right.
Deborah Robitaille.
All right. As you recall, ladies and gentlemen, the people actually started the rebuttal case, so we would keep moving. This is now part of that rebuttal case. Thank you.
Please raise your right hand to be sworn. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Please be seated. Please state and spell your first and last name for the record.
My name is Devra Robitel. It's DEVRA-ROBITAILLE.
Thank you. If you would pull that microphone right underneath your chin, we'll be better. Thank you. You may proceed.
Thank you, Your Honor. Good morning.
Good morning.
Thank you for coming and being so patient. Could you tell us what you currently do for a living?
I'm a composer. I do writing projects for different people. My most recent was for Disney.
And are you trained in music?
Yes, I am. I have a degree from Royal Academy and also Trinity College in London.
And you've been involved in music or the music business your whole professional life?
My whole professional life.
Okay. I'd like to take you back to the early 1970s, if I could. Did there come a time when you met a person by the name of Phil Spector?
Yes, I did.
Do you see him here in court?
Yes, I do.
And for the record, could you point to him and tell the judge what he's wearing now?
Yes, Mr. Spector's over there with a white shirt and a red tie and a black jacket.
Indicating Mr. Spector for the record.
Thank you, Your Honor. When you first met or perhaps first talked to Philip Spector, where were you? Were you working?
Yes, I was. I was working at Warner Brothers Records in Los Angeles. I had come over from England, and I'd been in the music business for a couple of years.
It's non-responsive at this point. Objection, move to strike.
Overruled. I think it is responsive.
Please continue.
I was working at Warner Brothers, and Mr. Spector called on the phone.
Let me ask you.
Non-responsive.
When you first met, she's putting it in a context, so the objection is overruled.
Let me ask you another question, okay? I think we have a question by a juror.
Oh, can you pull the microphone a little
Sure.
closer? It'll help.
Okay.
Okay, thank you very much.
Should I take a second to put my glasses on? 'Cause
Absolutely.
I think I can hear better.
I'm just going to let that one go. Okay.
Okay, thank you.
All right, thank you. Well, when you had this phone call, when you first talked with Phil Spector, you said you were at Warner Brothers Records.
That's right.
What was your job there?
I was the sessions coordinator, and I was in charge of basically making sure that people, when they went in the studio, didn't go over their budgets.
So you were in charge of a small department there?
It was under the auspices of the royalties department, and I was at the time this was going on, I was sort of policing the recording costs for groups like Alice Cooper and Jethro Tull, those megas.
And you had that job when this happened?
I'd been years.
And before that, very briefly, you had other positions in the music business?
Yes, I did. I had worked for Mercury Records. I had worked for Screen Gems, Columbia Music. I'd worked for MGM, various. Actually, Motown, forgot that one.
Now, when you first got this call, and you were sitting in your office when you got the call from Philip Spector?
Yes, it was actually a mistake. The switchboard had accidentally put him through to my phone. So we had this odd conversation, sort of trying to figure out who each other was, and he had been calling in to speak to someone else. So it was a mistake originally.
And during this conversation, I noticed that you have a British accent.
I do.
And you did that, obviously?
Yes, I did.
As you told us, you're from England.
Yes.
And that and your music, interest in music and the music business, did that come to play in this first conversation?
Yes, it did. Mr. Spector said he liked my English accent, and I think he was sort of imitating it, and we were laughing a lot. It was a lot of fun.
So the first conversation wasn't a quick, hello, oh, you have the wrong number. Let me hook you up with the right person.
Reading, also irrelevant.
Is that correct?
I'm sorry,
The first conversation wasn't a quick, oh, you have the wrong number conversation. It took a while.
Yes, exactly.
And as a result of that, did you continue to talk and have conversations with Phil Spector while you were there at Warner Brothers?
Yes, we developed a sort of a friendship. I actually hadn't met him yet, but he started calling through to my phone after that intentionally, and then he would ask me for who he would want to talk to, and I would put him through, or sort of I became like a liaison for him at Warner Brothers.
There between Phil Spector and Warner Brothers.
That's right.
Can you, and I know it was a long time ago, but in some way, can you try to tell us approximately when this happened?
Yes, I think It would be really accurate to say the end of 1974.
1974,
Yeah,
okay.
From the summer, sort of late summer.
Now, you said in your last answer that over a period of time, you continued to have conversations with Phil Spector about Warner Brothers records and trying to help him talk to the right people.
That's right, yes.
Did that relationship, that professional business relationship, blossom?
Absolutely, it did.
Please explain that.
Well, he started calling, and the more we spoke, the more we realized we had a sort of a spark. And eventually, Mr. Spector invited me to come down to one of the sessions and meet him. And, you know.
So you went to one of the sessions and you actually met him.
Yes, I did.
How long had you been talking to him on the phone when that happened?
We'd been talking for a few months by then, a couple of months at least, I would say.
And you'd become very friendly over the phone?
Yes.
But this was a professional business relationship.
Absolutely. It was very amicable, sort of a sparring friendship, you know.
And during your conversation, did you tell him about your background and interest in music?
Yes, absolutely, I did.
You were a pianist?
I was a pianist. I had a degree. I was a bit of a child prodigy, very precocious, a bit of a virtuoso in those days.
All right. Now, did there come a time while you had this job with Warner Brothers and after you talked with Phil Spector that you learned that he had formed a company with Warner Brothers?
I knew who he was when he first called because there had been a buzz in the record company about this new label called Warner Spector Records, which was being negotiated, and sort of my job was quite pivotal. A lot of things were sort of run through me, so I understood about the contract. I think I may have even read the contract, and I understood who he was.
So not only was he just Phil Spector calling into Warner Brothers Records, but he'd formed his own label in partnership, I guess, for want of better words.
That's right. It was a distribution deal, which means that he's signed to Warner Brothers, and Warner Brothers distributes the music that he made in the studio.
And the name of that company again was?
Warner Spector. Warner-Spector Records.
Now, into June of 1975, did there come a time when you left Warner Brothers and went to work for Warner Spector Records?
Yes.
Please tell us how that happened.
Well, I was invited to the session, as I mentioned to you. I think it was Cher. And I met Phil, and we went to another session, and it sort of grew and blossomed, and eventually I was finding myself This went on for another few months, and then Phil called me one day and offered me to become administrative director for Warner Spector Records.
And after he called?
It was a really terrific job. It was working in the music industry. I was a musician professionally, and that was my great love, and that was my great passion. And I wanted to be around musicians, and I wanted to be doing all the things that I was good at and that I loved. It was perfect for me, actually.
What were your duties as the administrative director for Warner Spector Records?
It was pretty broad. I had to book all the sessions, I had to book all the musicians, make sure they got paid, oversee the contracts, and we had unions. AFTRA was the vocal union and AFFM was the musicians union, so everything had to be sort of policed in a way that it was the rules of the unions. And I went to the sessions, I booked everybody, called them. I was in charge of making sure the liner notes were properly done, that everything was per the contracts, that everything was... I was a sort of a liaison, and sitting, I sort of have a picture of myself sitting on top of this big hill, making sure everybody walks in the right direction.
Working for Phil Spector.
That's correct.
Did your background and your work at Warner Brothers prepare you for this?
Absolutely.
But this was a bigger job in a sense?
Well, yes, it was much more interesting, and I'm not the sort of person, I didn't like sitting in an office from 9 to 5. It wasn't really my best favorite pick. So for me, working for Mr. Spector gave me much more freedom. I worked much longer hours. I mean, I worked from my home. I would go to his home and pick up things.
That's becoming non-responsive.
I think if you want to stop it, that's fine. I think it's very broad, but I also think it's still responsive, but it's up to you. You may proceed.
Well, I'll ask another question, kind of ending where you just did. What could you describe your interaction with Phil Spector after you went to work for Warner Spector Records as the administrative director?
Yes. I actually worked out of my home, and Mr. Spector had provided me with a typewriter and a phone, that sort of thing. And basically my typical day would be to get up, go to his house and pick up a package that he would leave for me at the back window. And in the package would be all sorts of things, my instructions for the day, who to call, you know, what sort of things needed overseeing, what sort of things needed doing. And then I would do those things. I'd go to Warner Brothers and meet with people. And then if we were recording a project, the next step would be to organize it and then go to the studio that night and be there present for the sessions.
And make sure everybody showed up and
Yes.
the work got done.
Exactly.
To some degree, were you the face to the rest of the music world for Warner Spector Records?
I absolutely was. At that time, Mr. Spector didn't interact that much, and I was his representative, so I would have the meetings with people on his behalf.
Now, you mentioned in an earlier answer that you often would go to his home, get a big manila package that would have lots of documents and your instructions. Is that
That's right. Yes.
Where was this home at the time?
It was La Colina Drive, which was sort of borderline Beverly Hills, just off Doheny and Sunset, behind the Hamburger Hamlet, actually.
You were there many times?
Many, many times.
Your Honor, at this time, I'd like to mark a document which I've shown counsel. I believe our next in order is 194.
I have 193, but let me double check. You have 194? What was 193? Okay.
It's 194. I'd like to get marked a copy of a letter to Warner Brothers administrators, staff, personnel from Phil Spector on Warner Brothers /Spector letterhead. May that be so, Mark?
Yes.
May I approach and give a hard copy?
Yes.
Thank you.
Thank you.
We have a 194 on the board. Perhaps, Sue, you could just be off. So we'll just go through this very briefly. And you have 194 in front of you. We've highlighted for those of us in the courtroom the top third. Do you recognize this document?
Yes, I do.
And what do you recognize it to be?
It's a letter that Mr. Spector sent to various different people in Warner's and various of his attorneys and other colleagues, announcing that I was to be his liaison, his representative at Warner Spector.
Well, it's announcing his appointment of you as the administrative director of his record label.
That's correct, yes.
And we see at the top, of course, Warner Brothers /Spector. That was the company name, correct?
Yes, that is.
And in the letter, maybe we could go down the middle third, please, Sudie. I would note that the letter has a date of Monday, June 23rd, 1975. Is that correct?
Yes, that's correct.
And is that approximately when you started this new job?
Yeah, yes, that is.
In the middle, I won't read it all, but it basically says that be informed that you are going to be the administrative director of Warner Spector Records effective immediately.
That's right.
And it goes on to say that you'll be handling all the matters with respect to that company.
That's
Is that right?
Yes. Yes.
And then the last third, please, Sudie. The bottom of the letter is signed Phil Spector, President. Thank you.
Yes.
Is that correct?
Yes.
Okay.
Correct.
So in end of June 1975, Phil Spector sent this a letter out, I think it was 194, to Warner Brothers and a lot of other people, I guess, announcing your appointment. Is
That's
that right?
correct, yes.
How long did you work in this capacity, just approximately, for...
3.5 to 4 years. Yes.
So if this appointment was made in 1975, you would have worked into 1978 to 79, is that correct?
That's correct.
Okay.
Yes.
During that those first couple years, would you say that these responsibilities increased or decreased?
I think they increased as I gained his trust.
And as you said earlier, it was intense, you worked a lot of hours.
Very long hours, yes.
Did there come a time when your relationship with Phil Spector changed from being purely a professional business relationship into something else?
Yes, it did.
Approximately how long after this appointment, this job that you got in June of 1975, did that happen?
It was quite a long time. I don't know exactly, but it was at least a year in to the job.
And what happened? How did it change?
We began a relationship.
A romantic relationship?
A romantic relationship, yes.
And is that something that you intended?
No, not at all. It was a big surprise to me.
But it happened.
Yes, it did.
And at that time, you found Phil Spector charming, what, intelligent?
Absolutely. Absolutely charming and intelligent. He was my best friend. I thought the world of him. He was my best friend. I used to just look forward to going over to the house. I would hope. Sometimes he'd be there and he would let me in and I would do things, you know, take down things or whatever. And we would sit sometimes and talk for hours and hours. I used to really look forward to that.
Did you play music together?
Absolutely.
You said that you're a pianist.
Yes.
With quite a background.
Yes, I used to play for him all the time, and especially at what I call the soirees. He would invite a lot of different kinds of celebrities over to the house, and those were sort of relaxing evenings in between recording sessions and that. And I used to call them the soirees, like in Paris.
All right. Well, I'm going to ask you some more questions about that in a moment. But let me ask you about your music and Phil Spector. Did he ever encourage you in your music, make you believe that you had a real future in this?
Absolutely, he did. I was also a songwriter back then. And he listened to a few of my songs and said they were great, and said that he would record them.
He encouraged you?
Absolutely, he did.
Tell us about that. I mean, did he say that someday he thought you could be a star, you could be an important person in the music business? What did he say to encourage you?
Well, it wasn't really so much overt. It was more subtle, just, you know, enjoying my music, encouraging me as a musician. I wasn't particularly insecure. And I certainly wasn't doing it for that reason. I was doing it because of the love of the work.
It's now becoming known.
It is. It's becoming a narrative non-responsive.
Strike that latter part.
The latter part is stricken. The reason non, I should disregard it.
Okay.
In an earlier answer, just a moment or two ago, you mentioned I guess for one better term, some party get together in his home.
Yes. Yes, did.
What did you refer to them as?
Soirees.
Okay. Duty, relationship there. I mean, did you have some business relationship as these parties put on duties that you had to do?
Yes, I used to organize the whole thing and then attend it. And oftentimes I would just sit and pretty much wait for it to finish.
Did you sometimes play the piano?
Often played.
And did sometimes these last for a while?
Yes, they did.
Well, I'm going to ask you about first one in particular where I think you told they were the last man standing.
That's right.
What does that mean?
I worked for Mr. Spector as an employee. I was sort of a guest, but sort of not a guest. So I was always a bit separate from the festivities, if you will. And so sometimes I would sit in another room or I would sit in the kitchen. Sometimes Phil would come and get me and ask me to play the piano, which I would. And then I'd sort of go back or read a book or that sort of thing. And pretty much always the last one to leave.
Well, I'd like to talk to you about one of these times where you were the last person to leave,
yes.
Where a rather startling thing happened to you.
Yes.
Do you have that in mind?
Yes, I do.
Okay.
Okay, we're gonna stop there. I think I know I think I know what she's gonna say, y'all. What do you think she's gonna say? She wanted to go home, and he didn't want her to. I betcha. So we'll leave that for tomorrow, because we got a trial to get to, and I need to clean my cache and my cookies so StreamYard behaves, and I need to take a little break. So we are going to save that for tomorrow. Let me write down my timestamp. And we will get back to her tomorrow. I was going to listen, and then I was like, let's listen what she has to say. I lost my ball of yarn. But I think I know what she's going to say. So we'll save that for tomorrow. Because I have a feeling, because this is the state's rebuttal. Wonder why. I wonder why they decided to leave her for rebuttal. Like, in the case, the state's case in chief, they had this whole lineup of women who said, I wanted to leave, and he brought out his pew pew, and then they saved her for rebuttal. I wonder how many women are going to be in rebuttal. They're going to say the same thing that all the women said in the case in chief. I know Pumpkin's coming back, and the other chick, Hayes Rydell, I forgot her first name, or Rydell, whatever. I don't know why they're coming back for rebuttal, but they are. Whatever. So we got that coming up tomorrow. So now we're gonna go to the Widow's Words murder trial. And so the feed will redirect. If you're not going to join us for that, I will see you in the morning for more Phil Spector. If you are, I will see you over there in about a little over 10 minutes. I'm going to take a quick break and be kind to people. Love your family, and Jesus loves you, and so do I. And I will see you in the morning or in a few minutes. Bye, guys.